screens here and can see you clearly. Just give us a moment. There's something on our screen that will probably go away in a moment. There we go. All right, Mr. Schuler, what would you like to tell the court about your client?
Thank you, Your Honor. And for the record, again, Michael Schuler, Associated Counsel for the accused, along with my social worker, Ms. Alex Willard. We're here on behalf of Mr. Gregory Nelson, who is appearing via Zoom from the Department of Corrections. Did the court receive the pre-sentencing report I sent in about a week ago?
I did, thank you, and I was able to review it.
Excellent. So, as I said in the pre-sentencing report, I think this is actually a pretty unique scenario. I know we are just starting to have these 5164 resentencing hearings, and frankly, I'm so glad that these things are happening. I'm so glad that not just Mr. Nelson, but a number of people are going to get actual second chances at life. And I want to say before I begin, truthfully, thank you to the prosecutor's office for identifying these cases and for working with defense to really, I think, effectuate justice as we conceptualize it in our justice system, that our clients who have served their debts to society and who've shown their ability to be rehabilitated are getting a second chance to come out into the community. Mr. Nelson and I have communicated quite a bit while he's been in custody, and I've got to learn a little bit about him. I have not had this case for a very long period of time, so I'm sure he'll have a lot to add to this. But what I want the court to know beyond what was in the pre-sentencing report, he intends to live with his mother. She's 82 years old. He is going to stay with her, help take care of her when he gets back in the community. While he's been in custody, he has done everything he can to avail himself to a number of rehabilitation programs. It's actually been difficult. We learned through doing this process that folks serving life sentences were given very low priority to get into DOC programming. I think for the somewhat obvious reason of if they're not going to get released, why would we give them programming? Despite that, Mr. Nelson persevered and continued to agitate to get programming for himself in an attempt to, make his time spent in custody meaningful. And so I'm hoping I'm not forgetting anything, but he's completed the following programs while he's been in custody. He completed STOP. He completed Omni, which was a DOC substance use treatment program. He completed MRT. He completed 2 different anger management programs, a program called Redemption, cognitive-based change program, life skills program, parenting skills, keyboarding skills. He achieved a GED while he was in custody. He took numerous job training programs, including food service handling, safety, health and sanitation, custodial course certificates, Freedom Tales, and parallel community orientation. So he's done quite a lot while he was in custody to make the most of his time. He's also spent the time working with the Department of Corrections, doing a lot of work for them. He's currently employed as a cook. He's been employed as an electrician, a plumber, a janitor. He's worked with the Department of Natural Resources as a firefighter, a tree planter, park care, thinning out trees to ensure that there aren't additional forest fires. He's done sewing machine operations, laundry, and ceramics as a kiln operator and a teacher. Mr. Nelson, I think, as you can see, has taken a lot of time to work very hard on being productive while he's been in custody. As I noted in the pre-sentencing report, the Gregory Nelson in 1999 is so different from the Gregory Nelson 22 years later. In 1999, Mr. Nelson was in the throes of serious substance abuse disorders. He has tackled that while he's been in custody. He has not had any substance use issues since at least 2013. So we have about 8 years of time in the community or in DOC where he has been doing well, been clean and sober. He's had no infractions since 2013. So again, just shy of a decade, he's really been working hard to be a model inmate and show that he is a different person than the person who was sentenced in 1999. I think it is, again, fantastic, and it speaks so much to the character of Mr. Nelson that he was able to do these things despite the fact that he was serving a life sentence and despite the fact that DOC did not prioritize him for these programs. I think that really does speak to his character and who he's turned into. When he is released, he will, as I said, stay with his mother. He also has a large community safety network that's out there. He's got friends who are life coaches. He has a good friend community in the Shelton area who intend to support him in this transition back into the community after being in for 22 years. That will support him in making good choices and continuing his sobriety and ensuring that he is successful. I think everybody in this courtroom, and I think Mr. Nelson as well, all want him to be successful. This is truly a second chance at his life, and I know he is eager to jump at it, and he cannot wait to be released. I think he's going to make a stop at McDonald's when he gets out of here, since he's been craving that for little over 2 decades. So if Your Honor has any questions, I'm happy to answer them. If not, I think Mr. Nelson would like to talk to Your Honor about who he is now and how he's got to the place where he's at.
Thank you, Mr. Schuler. I don't have any questions. Thank you for that presentation. Mr. Nelson, we are sort of resentencing now, so there's an opportunity for you to say something to the court if you'd like to. You don't have to, but this is your opportunity if you'd like to say something.
Well, first of all, sir, I'd like to correct something that I believe, was that Miss Carla Lee that spoke first?
It was.
So there was something mentioned in there about assault on a child. Are you sure you got the right person on that? Because I've never been charged of any kind of, or accused of any kind of assault on a child. And I would never want that on my record. So let's get that cleared up right now, please.
Yeah, I don't think I heard that, Mr. Nelson. Maybe there was something, a glitch in the video, but I don't think Ms. Lee mentioned anything like that.
All right, great. Other than you know, I've come a long ways in my transition in life, and I'm no longer the young kid or the young man who was struck by a disease at a young age. And a good friend of mine, Annette Johnson, was my mentor and helped me figure out what was going on with my mental condition. Something called the ACE score. It's an adverse childhood experience. And once I learned what that adverse childhood experience was, I learned how to deal with my addiction or my disease. So all I really have to say is I feel great about who I am today compared to what I was then. And I am done with any kind of crimes, and like my attorney says, I just want to go home and be an asset to the community and just live the second half of my life right. And that's about really all I have to say.
Thank you, Mr. Nelson. I appreciate those comments here. I, first of all, want to commend you for taking advantage of some of the programming. I know it sounds like it was a challenge to get enrolled in that, but I'm glad that you did. I think the hallmark of living the life that you would like to live involves making sure you have the structure around you to support you so you can make good decisions. Obviously, at the time of these incidences, you had a serious substance use addiction. And now you've been taking classes and learning more about yourself and discovering what those triggers are. And now the real test is being able to apply that information when you're out in the rest of the community. There will be lots of stresses and temptations and other things that go on. And it's really important for you to remember how you want to live your life, how clear-headed you are right now, so that you can make good decisions and surround yourself with folks who can support you. There are lots of people in this community, and it sounds like you have a few of them in your corner, that will assist you and help you get over those challenges that you'll inevitably face. But if you can do that and really follow through on your commitment to sobriety and changing your life, you can have a very rich and fulfilling life, reconnecting with your family. Sounds like they're an important part of your life. And hopefully get that second chance so you can do the things you want to do, including getting that hamburger at McDonald's. So I encourage you to just keep reaching out, to keep working hard on your sobriety. Sobriety is not given to anybody, it's earned. And you, if you keep working at it and keep reaching out, you can attain and achieve all of your goals. You know, as you can see here, you've spent 20 some years in prison. and more before that, that life is very short. You have only a minute on this earth. I encourage you to take advantage of that and really give to your community, give to your family, and be the person you want to be. So with that, I will follow the recommendation, impose the maximum here, which is 84 months, have that concurrent to each other, and I won't impose community custody. Obviously, that is, since you've served all of the time here in these cases, that would not be appropriate. I think the rest of the conditions, including the no contact orders, would remain in effect, and I will impose the no contact order. I don't know if the victim penalty assessment was ever paid or not. If not, that would have to be imposed as well.
You know, Your Honor, it's interesting on the JNS, the VPA was not ordered in this particular case on the 1999 JNS. So I wasn't sure how we wanted to proceed on that. I know that it's something that's ordered today, but we would be willing to waive if the court is, we wouldn't have any objections to waiver if the court waived.
All right.
I understand that those are mandatory.
Yes, I think the
That's
issue
nice.
here is at the time of the offense and the time of original sentencing, I don't have that information if the VPA was mandatory at that time. Obviously, it is mandatory this time. Do you know, Ms.
Right.
Lee?
You know, in our research, Your Honor, we couldn't find that it was mandatory at that time. And so we're assuming that it wasn't mandatory in 99, but it is mandatory today. And according to 5164, I'm assuming that it may have to be imposed. But like I said, the state has no objections if there is a way to work around.
All right, I will waive the fee, given that there is some ambiguity there. Obviously, the DNA sample has already been taken. I think the other issue is restitution. And so I think the court will order restitution at this point in an amount to be determined at a later date. Does your client waive appearance at a future hearing?
Mr. Nelson, what that means is if restitution is sought or requested by the state, they have 6 months from today to do it. You can be present at the hearing, or you can just let me handle it. The risk, of course, is if you want to be present and then you're not present, a bench warrant could issue. Your call, though.
You're talking about restitution for the victim's compensation?
Yes, the state, it's unclear. The state has a right, since it's a resentencing, to request it within 180 days of today. I don't know if they will or not, but they can. And if you wish to be present, you can be.
They've been taking victim compensation out of my paycheck for 20 years. So where's that money been going? I think I paid for victim's compensation a long time ago. So I have no objections of not being at the hearing.
If that comes up, Mr. Nelson, I'll look into it. I expect that you're correct, that given that they have been taking things out of your paychecks, that it has already been paid for. But if not, and something comes up, I'll do the research and I'll contact you and let you know. Okay?
That's fine. I don't mind not being at the hearing.
Perfect. Thank you.
All right. Sounds like Mr. Nelson's waiving his appearance at a restitution hearing. So I will sign. Well, I think, Ms. Lee, you've arranged for Mr. Nelson to be fingerprinted. Is that right? So we need to have that happen on the camera. And then if the DOC officer could show to the screen the fingerprinting sheet so that our clerk can verify that it was done properly, and then she can put that on the record.
Yeah, Your Honor, we have our fingerprint person here. She's also a notary, so I will go get her.
Thank you.
And Your Honor, while that's happening, just to keep the court apprised of other things with the judgment and sentence, Mr. Nelson and I in the breakout room went over the notice of ineligibility to possess a firearm and loss of rights to vote, as well as his notice of rights on appeal and rights pursuant to RCW 1073. There were no questions about either of those, and we can acknowledge receipt of them, and he'll affix his signature as soon as he's able.
Thank you. And so, Ms. Lee, once the fingerprinting is done, how will the parties and then the court get the judgment and sentence to sign off on?
So, Your Honor, it's our understanding that DOC will mail that information to the clerk's office once it's completed. the clerk's office will then file at that time. So far, we've been noticing a pattern of sometimes the documentation, the JNS that we have, the incomplete JNS is filed. Then when the fingerprints come in, they're filed. Those are then filed to complete the process. And then there's an order given to DOC for release. That's our understanding, but sometimes it operates a little different for each case.
And so will those documents come to the court for my signature?
Yes, Your Honor, they will come to you, and then the clerk is to bring that to you, you're to sign, and then the clerk takes it from there.
Okay, thank you.
We're ready for fingerprinting, Judge, whenever you are.
Go ahead. Thank you, officer.
Oh,
Good morning.
All right, this is right hand, so I think we're good. Oh, and then is. And I'm gonna pen here for you to sign. And his date is. Thank you very much.
So if you could show that to the camera there, ma'am, so that we can, my clerk can just review it to make sure it comports with what we need.
Sure can. It does just say right hand, so I've only done the right hand. Is that okay? Can you see that all right?
Yes, we can see that.
The clerk has verified and attest to the defendant's fingerprints via Zoom.
Thank you. Thank you, ma'am.
You're welcome. And also, I was also notified about a possible notary. I don't see a spot on these documents for a notary. Do you? I am a notary public. Is a notary needed for anything else?
Not that I'm aware of.
We do prefer it, but if there's no indication, then that's okay.
Okay. Thank you.
Thank you, ma'am. All right, counsels, anything else to accomplish on this matter?
That concludes the state's concerns, presentation.
The only thing that I'm just hoping is to interlineate on the judgment and sentence, make it very clear that Mr. Nelson is to be released today. I know sometimes on some of the Blake matters, we've had some issues with the Department of Corrections, if it's not explicitly clear.
So, Your Honor, in order to address that, we've included a document that we'd like the court to consider signing, which does make it clear that we are expecting immediate release. Now, whether DOC can release somebody the same day, I'm not so sure about what their process is. There may be some processes that they have to go through in order to do that. But we have made our intentions clear that we would like immediate release, and we have that included in the packet for the court.
Right. So am I supposed to sign that now, or?
Yeah, and that's all part of the judgment and sentence that's supposed to be signed. Should I pass that forward?
Please.
Your Honor?
Thank you, Ms. Lee. Setup so we can see the whole corner. I'm not sure. I think so.
All right, so I've signed the judgment and sentence as well as the order for immediate release. And so Mr. Nelson, DOC will process you once they get the order, and whatever their process is, then you will be released from at that point.
Thank you, sir.
All right, anything else, councils?
The only thing I can think of, Your Honor, is that we're going to have to sign that as well.
Okay, I'll hand that down. All right, that concludes the matter. Thank you very much, everyone, for getting onto the Zoom call. Thank you, officer. That concludes the matter.
You're welcome, Your Honor. Thank you.
Thank you, Your Honor.
Thank you.
Have a good day.
You too, Mr. Nelson. Good luck.
Thank you.